Allegation against me is concerned, my lord, that is on in page 15, my lord. One paragraph. May I read the relevant paragraph, my lord? It was admittedly, my lord, it was recovered from my lord, one Salma Begum, my lord, from her inner way, my lord, while he was transporting with my lord Shiraz Ali, my lord, and page 15, first paragraph, my lord, during spot interrogation, the accused, namely Muhammad Salma Begum alias Pinky and Shiraz Ali, revealed that they went to Dimapur today morning by scooty bearing registration number such and such to procure narcotic drugs. On the same day, they purchased 6 soft cases of suspected heroin at Dimapur with the intention to sell them at the Golaghat area. They also admitted to being involved in drugs trafficking for a long time. The suspected heroin was supposed to be delivered to one Suraj Setri, mobile number census. Petitioner before your lordship is my lord Suraj Setri. Otherwise, my lord, neither the my lord Alice contraband was my lord recovered from the possession of the petitioner, my lord, nor my lord the Alice contraband was my lord
Was
recovered.
supposed to, that is,
And
They are going to deliver it.
deliver. This is, the police, wrote this on the basis of their materials, or it is on the basis of statement of this, only
It will be
statement
on
of
the-
this.
On the basis of statements of the other accused.
that is also my lord from the FIR, my lord, it my lord not
It is
my lord
revealed
clear.
that, no, so and so, maybe, yes.
Only this line.
Investigation is
Otherwise,
going
my
on,
lord,
it will be required.
it is my lord from the FIR itself, it is very clear, my lord, it was neither recovered from my possession, my lord, nor my lord, it was recovered at the instance of this petitioner, my lord. And further, my lord, only on the basis of the statement. my
In
lord,
the narration before, this paragraph, there is no reference to you.
No, my lord.
There is no reference to
No,
you.
no, no, only that line. my lord.
They were arrested, and when they found my lord, they said that it has to be delivered to the petitioner.
Only that was.
That is the allegation.
Other my lord, there is absolutely nothing in the affair to show that my lord, in any manner, my lord, I am involved in my lord the conspiracy.
That will come after investigation.
Only because of that line, my lord, now I am never suffering. So my lord, let the city make also, my lord, in the meantime, my lord, I may be protected. Considering my lord, this facts and circumstances. my lord. Had it been my lord recovered from my position or in any way, my lord.
So that is an important thing to determine. If the only material is that statement of co-accused, then perhaps
That is
Even then, my
a
lord,
different thing, my lord. But now at the stage of investigation, my lord, 161 carries the value, my lord.
When if my lord for time being, it was believed that my lord is the co-accused has made the statement against me, my lord. There also, my lord, in trial, my lord, it cannot go against me, my lord. Tufan Singh is there, my lord.
We are not on
Considering-
trial, my lord.
how much
Therefore,
quantity was
Only 76 gram, my lord. That's
76
my
gram,
We are
very
not
much
on trial.
fine.
don't say only, I mean, heroin is a heroin, no?
We are not on trial.
It was my lord recovered from the possession of my lord Salma Begum from while it was concealed in her my lord inner room.
Mhm.
These types of, my lord, always a
Remotely
organized
also, my lord, I
crime,
am
my
not
lord.
involved.
That is true, but the
Not
thing
a
is that
single allegation, my lord, except this, my lord, in the entire affair, my lord, not a single allegation, my lord. And it is also, my lord, absolutely nothing, my lord, in what manner, my lord, I have involved, and nothing is there, only that line.
which police station?
It is from my lord.
Horu
Swarup.
Pathar. Horu Pathar, okay. We can ask him to record his statement, but provided we get the case diary short within maximum 10 days.
I have objection regarding
of
the
course.
interim, my
Yeah,
lord.
of course,
Lord-
you'll
Lordship
have
may not-
objection, because that is the thing.
Yes,
If the only
because
material is
We do not know.
some, statement of, it will
I-
become clear from
There's
that.
161, my lord, now.
But
my lord,
his story, because why this law has been made, it's a very sound law. It is only at the stage of trial to Fansik,
Yes,
but
understood.
it can be taken into account at the stage of bail. But because if the only material is because any statement of like accomplice or co-accused is always, there's
Yes,
always a question mark. His credibility is less.
Yes,
So if somebody's name surfaces through the mouth of some co-accused, then just imagine the risk to a person.
Yes.
Anybody will name someone, and then
Yes.
he can be,
Yes.
thing. So that is why this law has been made.
It's a balanced. man.
Yeah, it balances
Yeah.
liberty and this thing. And
Yes.
of course, if there are some materials, then it will take. Then it will no longer be only statement of
Because-
co-accused. It will be something else. Then you can determine.
Yes,
Yeah,
sir.
I am ready
There
to
is
cooperate
also,
in
my
any
lord,
manner.
several decisions which says that my 161 at that stage of investigation has to lead to the, my lord.
The third so and so, the petitioner Suraj Setri seeking anticipatory bail in connection with Horu Pathar PS case number 56 of 25 under section so and so 25. The FIR was lodged on 10/10/2025 by the police official of Horu Pathar PS. it is stated inter alia that upon source information, operation was carried out, whereupon co-accused Muhammad Salma Begum alias Pinky and Siraj Ali were apprehended apprehended on their scooty, right? They were in a
Yes.
scooty
Yeah.
bearing number AS05L1889. And they were found to be in, and they were allegedly found to be in possession with suspected heroin quantified at
76 grams.
76 grams, thereby falling in the bracket of intermediate quantity. The learned counsel has drawn my attention to the relevant paragraph of the FIR in which it is stated that it is stated that the suspected heroine was supposed to be delivered to one Suraj Setri. Full stop. It is submitted that the name of the present petitioner surfaced only from the statement of the apprehended accused person. The call for the case diary from the concerned police station. It is the learned additional public prosecutor opposes the prayer of the petitioner for grant of interim bail. In the case of Tufan Singh versus State of Tamil Nadu, the law has been settled by the Honorable Supreme Court that statement of a co-accused cannot be the sole basis of conviction. Though no case law has been brought to the notice that at the stage of that if the only material is the statement of the co-accused, the petitioner has to be granted bail. Nevertheless, I am of the considered view that in the context of the principle laid down in Tufan Singh Supra, the said aspect can be taken into consideration at the stage of adjudication of the bail. In the instant, next paragraph, in the instant case, at this stage, it appears that the incriminating material against the petitioner is the revelation from the co-accused, apprehended co-accused. Therefore, I am of the view that till the arrival of the case diary, he should be given an opportunity to record his statement. In such view of the matter, it is directed that in the event of so-and-so, 30,000 with one security, cooperate with investigation, appear before the IO, making himself available for examination. Hamper or temporal dividends shall not commit any activities violative of the NDPS Act. Violation will entail cancellation of the bail. This is the matter on not very long, because otherwise we do not know what materials are there. They may be part of a racket also. They may not be also. He may be just a consumer also, or he may be innocent also. So to propose a date.
Anyway, my lord, they have to record the
Third.
statement, then yes,
Third,
third.
you ask him to go and record.
Obliged.
They have to give their statement before that, my lord.
Yes. Third will be okay, or fifth?
Let it be fifth, my lord, because within 3-4 days,
Yes, fifth.
Yeah,
He's saying
fifth.
fifth. That's better.
Within 3 days, I will recognize.
within 3 days you can appear.
May I please, Your Lordship, my lord? My lord, this is a pre-arrest bail application, my lord. FIR is page 10, my lord, page 10.
Cite him, Chen.
The allegation of my lord kidnapping is there, my lord.
Okay.
It's a purely love affair, my lord. Between the my lord accused number 1 and the victim there, my lord. What happened in this case, my lord?
I am on the Azhar. Shall we read it? We shall
Yes.
read.
Yes, my lord. May I read, my lord?
Okay.
Humble submission is that on last 27/4/2005 at about 1 AM, taking the chance of absence of male persons in our house, the aforesaid accused persons in group unauthorizedly trespassed into our house and while forcefully kidnapping my minor daughter, Miss so and so, 17 year 10 months. Although the female persons of our house started hue and cry, but the accused number one, with the help of other accused, escaped with my minor daughter. I was informed by my family members regarding the said incident, and on the next day I reached house. On last 30/4/2025, I, along with the help of so and so, could recover my minor daughter. The girl has been recovered, my lord. It is purely, my lord, a love affair, and because of, my lord, a social bad relationship, my lord, between the informant and the accused number one's father, my lord. This affair has been lost, my lord. Later on, my lord, they have compromised the matter, my lord. By virtue of, my lord, a memorandum of compromise, my lord. And my lord will kindly come to page 13, my lord. The serial number is wrongly given at column number 8, my lord. Page 13, annexure 2 for a moment, my lord. They have settled down the dispute for filing of the affair. And the girl is, my lord, only 2 months, my lord, shortage, my lord. She is well capable of giving consent, my lord. 17 years, 10 months, my lord.
Age of discretion, but still technically minor.
Technically, ma'am.
Technically, my lord, yes, my lord. No, she will kindly consider, my lord, that part. She is a consenting party, my lord. They have love affair, my lord. This is probably
But, do we have something, because nobody
My lord,
there
in
on
the-
the other
in
side
the-
to
the
confirm
rejection order,
the
my lord,
settlement.
That is notice. as
My
to-
lord,
Hmm.
in the rejection order itself, my lord, lordship, the Learned Trial Court has not found anything, my lord. Page 14, my lord, answer 3, my lord.
There is a
Only they
formality,
said,
ma'am.
my lord, considering the nature of offense, my lord. Privilege of PSB cannot be granted to the accused number one, my lord.
Because,
Nothing is there, my lord. It's a purely allowed.
things, no,
But
but
she will kindly consider, my lord, my
it
interim.
must, it may be true, but
Yes,
at the moment, we do not have anything to, to lend support to this agreement, right?
Yes,
So
my lord,
you
but
issue
if anything comes, my lord, against me, my lord, I shall not press this petition, my lord. Lord, she will kindly consider my interim prayer, my lord. It is purely allowed affair, my lord. Nothing else, my lord.
because we do not even know, I mean, you have stated, of course, that
Yes,
must be true, but again,
Yes.
from record, we do not have anything to,
Let the record
to
come, my
confirm
lord.
the recovery of the girl.
Yes,
Because
my lord,
there's
let
a
the
AB,
record
there's
come.
no
She has
forwarding
been
report.
recovered, my lord, even.
There's no forwarding report.
It is not that, my lord, she has been kidnapped and kept somewhere else, my lord.
Let
She has
us-
been recovered, my
let
lord.
us-
On the very next day, my lord.
I think it will be better to call only for the case diary.
Yes.
My lord will kindly consider, my lord, my interim, my lord.
Because otherwise, apart from your contentions and these materials, we do not have anything, anything.
Lord, they have
Even-
a memorandum of understanding, my lord, have been executed, my lord. Has been executed by both the parties, my lord. They have put their signature, my lord, in fact.
Heard so and so and so. Petitioner is seeking anticipatory bail in connection with Morabari PSK 76 or 24 under so and so. Full stop. The petitioner is stated to be aged 19 years. Full stop. The learned counsel has taken the court through the FIR dated 2/5/2025 lodged by one Mahuruddin, alleging that on 27/4/2025, in the absence of male persons in their house, the accused persons named in the FIR trespassed into their house and kidnapped his minor daughter aged 17 years 10 months. And oh yeah, FIR is mentioned about recovery,
Yes, last line, my lord.
and that subsequently, with the help of the police, his daughter could be recovered on 3/30/2025.
He is admitted.
The learned counsel submits that the petitioner and the victim girl who's on the verge of minority, as per the petitioner, as per the learned counsel, as per the submission of the learned counsel dash, were involved in a love relationship, and that there is no any offense of kidnapping or other offenses under the POCSO. He has also drawn attention to one agreement dated to 2025 between the informant and who's Moinul Haq?
Moinul Haq is the father of the accused. my lord.
And
Petitioner.
Moinul Haq, father of the petitioner boy, whereby the parties are stated to have acknowledged the relationship between the parties, which was between the girl and the boy, which was not accepted earlier, and stated about amicably settling the dispute. On the basis of these materials, the petitioner side 6, interim bail. Call for the case diary from the concerned police station. The petitioner shall also take steps for issuance of notice upon the respond number 2. You have not implemented upon the informant to be effected through the concerned police station, jurisdictional police, concerned police station. So stop. In the given fact, in the given circumstances, it is directed that in the interim, in the event of arrest of the petitioner in connection with this case, he shall be allowed to go on bail of rupees 25,000. With one surety of the like amount, to the satisfaction of the video. Subject to the condition that cooperative investigation appear before IO, not hamper or temporary debates, not harass or harm the informant side. So, list the matter.
One minute.
The
Twelfth night.
learned additional PP opposes the grant of any interim protection. List the matter on
12th minor.
12.
Deeply obliged.
Very pleased, your lordship.
Yes.
Your lordship, anticipatory bail application, FIR at page number 13, your lordship. May I read the FIR, your lordship?
Yes.
I beg to lodge this
Caput,
first information report, your lordship.
Yes.
Page number 13, your
Uh,
lordship.
Page number
13, 1
1 3.
1 3.
Okay.
On the basis of confidential information and witness statement, it has been revealed that Iqbal Hussain, son of Moinuddin, along with his family members, namely Moinuddin, Amjad Ali, Muslim Uddin, related to Moinuddin, all residents of Chirang Pathan under Murajar police station have been involved in selling cow meat for a long time. The said illegal activity has been carried out within a 5-kilometer radius of a temple. On 17/9/2025, during a raid conducted at Chirang Pathar, approximately 25 kg of suspected cow meat was seized and one tarazu along with 6 numbers of weight, 1 kg, 1 number, 500 gram, etc. from the house of the above named accused persons. However, the accused persons fled from the place of occurrence before they could be apprehended. Witnesses of the occurrence, the seized meat has been sent for veterinary examination, your lordship. This is the primary allegation, your lordship. The 25 kilograms of meat was found in the residence of one Moinuddin along with his 2 sons, Iqbaluddin and Amjad Ali, your lordship. The petitioner number 4, Muslimuddin, is not a connected person. How his name got incorporated in the FIR is not known to the person also who has been petitioner, your lordship.
That's
We are seeking protection, your lordship, for recording our statement, your lordship, with regards to the simple fact that whether slaughtering has happened or not, your lordship. That is the main crux of the entire FIR. your lordship.
selling is what is the
Selling-
regulation? It cannot be sold
It cannot.
vicinity of temple.
Our
Obviously.
contention is
5
that we are
kilometers.
not selling the meat. There was some kind of meat present in our house, which was purchased from an authorized dealer, which comes in packets, your lordship. There are some tiny packets which comes from outside the state within the entire state, your lordship, and that is circulated. That is permissible also, your lordship.
There is no
However,
slaughter. Slaughter is banned.
Slaughtering is bad, your lordship. There is one thing. There is no allegation of slaughter. First thing. Secondly, if your lordship may come to petitioner number 2, your lordship, Moinuddin, his age is 63 years. What happened here is, lordship, the police came to the house. They found Moinuddin in the bed, your lordship. He had a bank clip. So the police themselves could not carry him to the police station, your lordship. However, his name remained in the FIR and the police asked him to surrender 2 of his sons, your lordship. He is present in the house. He is in his bed. The police officer saw him but could not carry him to the police station, your lordship. He is already 63 years old. And the other person who is petitioner number 4, that person is, your lordship, not connected in any manner to the entire house or the territory or with regards to the sale or transaction, your lordship. May we be protected at this stage, your lordship.
Which are Muslimuddin.
Muslimuddin, lordship. Petition number 4, your lordship. 2 and 4, I am pressing for interim protection, your lordship.
2 and
One,
4.
the police themselves could not carry him to the police station, your lordship. He is a layman laying there with a back limp, your lordship. 63 years old petitioner, your lordship.
That slaughter is prohibited by the cattle preservation.
Cattle preserve. This is not slaughter also.
So, there should be mutual respect for each other's feelings.
Indeed.
Then only we create a harmonious society.
Your lordship, the
Section
place
Eight-
which has been mentioned.
Section 8, we go for the section 8 of the Cattle Act, madam.
Yes,
It
yes,
bans both slaughter and selling, madam.
yes.
Indeed, your
Uh,
lordship.
Selling
We are denying-
selling will also be banned.
Selling. So only saying that there is no slaughter
Mm.
or selling.
Mm.
That cannot be a point, madam. It is very much specifically
Or-
stated, madam.
Yeah, let's go.
So they are against the law they are doing,
Mm.
madam.
Lord, additional PP for the state. The 4 petitioners hearing are seeking anticipatory bail in connection with Murajhar PS case number 183 of 25 under section 13(1) Cattle Preservation Act. The case arose out of an FIR dated 18/9/25 lodged by police official of the aforesaid police station, naming all the four petitioners in the FIR and alleging that there was information about uh, about illegal sale of cow meat from that area, and on 17/9 a raid was conducted, and whereupon 25 kg of suspected cow meat was seized. The name of two witnesses have also been mentioned. It is stated that the meat has been sent for veterinary examination to confirm its nature. The learned counsel submits that petitioner number 2, Moniuddin, is a 63-year-old person, and though the police wanted to arrest him, but he was bedridden and could not be taken to the police station. It is also submitted that petitioner Muslimuddin is not at all connected to the alleged incident, and he has been wrongly incorporated in the FIR, arrayed in the FIR as an accused. Arrayed. Full stop. Anyway, call for the case diary from the concerned police station. However, in the interim, the event of arrest of so and so and so and so, 2 and 4, in connection with this case, 25,000 each, security of the like number. Cooperate, record their statements, and not indulge in any activities violative of the Cattle Preservation Act,
Much obliged.
2021. List the matter on, you fix it slightly longer, 15, 12.
Much obliged, deeply.
Bail hearing AB 28.
Supply to
I have of this. I'll link you over.
supply line.
Section 8.
Anyhow. Don't overweight, huh?
The bail hearing BNR bail hearing.
28 minus something. Oh, sorry, AB. A2. Get over. Listen, that's what we'll come back to. Okay. No, timing code is 9, 28. Not ready.
29.
May please,
So, Chetri is. Jorat piece.
FI is 16. Long FI. The main accused has been already arrested and released on bail.
Husna Begum.
Lordship.
29.
I am nowhere in the FI, your Lordship. Only doing
I
the,
think 29 months, charge sheet laid down.
Hmm?
Charge sheet laid down.
Charged is fine.
Charge sheet filed.
He has been sent off for trial.
Yes.
Javed Ahmed. How is he connected with Husna Begum? What is your instruction?
local of that local. Nothing else, sir.
It is not clear whether he has been sent or not, my lord.
It's not clear.
It's not clear.
Can you take
Yes,
instructions? Can you take instructions?
It's
Let me read the FIR just one.
Day after tomorrow, we can take the
Inspector.
instructions.
So and so, so
If-
and
So he has no apprehension if he is.
so.
sent.
FIR is not mentioned. But then we have to really take the instructions.
Yes.
He may not have been set up also, but he may
Perhaps,
have,
my lord, he may not have been.
he may not have been. Day after
Day
tomorrow,
after tomorrow, I'll. at least,
instead of, Mr. Chetri, the learned counsel drawing attention to the FIR, submits that he is not, the petitioner is not named therein. Full stop. The learned additional PP submits that the case has already been charge sheeted, but it is not clear. The case arising out of Jorhat PS 233 of 25 is already charge sheeted, but it is not clear as to whether the present petitioner Javed Ahmed has been sent up for trial and seeks to take instructions accordingly. Stop. List the matter on what will be the date? 27.
27. lord.
27/11. The column of bail hearing. I'm very familiar with this Husna Begum of
Your
Jorhat
lordship order there.
because I
Lordship order.
handle anyway, we should not prejudice,
Obliged.
but very familiar with her. Several I had remanded also. Several cases. Anyway,
Number 30,
One thing, my lord, I'm sorry, my lord, regarding item 11, lordship may kindly record my objection regarding.
Yes,
the
yes.
item. I'm deeply obliged.
yes, sure.
But here city was called for
Item?
33.
Forest.
Milord, your lordship will
Please.
turn to page 11. FIR, Milord. It starts from.
Page 11.
Page 11. Page 12, man. First information contents.
Okay. Very small letters. Accused Mufasina Begum.
So your lordship will
So-
next turn to page 14. In the middle, my lord, they arrived at
What was the quantity they mentioned? Quantity
10.5.
10.5.
Your lordship, in page 14, my lord. Page 14, in the middle, my lord, they arrived.
Yes.
They arrived at Borbari village. So and so. 8:30 PM, and after that, we make a trap by engaging one source along with accused person, Sadiqul Islam. At the moment when the accused woman, namely Mufassina Begum alias Mubasina Begum, wife of Khairul of the name village, trying to sell drugs, that is suspected heroin in lieu of money, we caught them red-handed and after found 8 plastic bags, so and so on. Now your lordship will turn to page 15. Para 3, my lord. Ground of reason of arrest. On 31/5/2025, at night hours, the apprehended accused woman, Musammad Mufassina Begum, 23 years, wife of Khairul. So and today information received from IC Saddagriha Morigaon that she apprehended woman has fled away. So my lord, I deny this fled away, my lord. Because my lord, I was in Saddagriha. And after night is over, my lord, up to 10, my lord, no police officer came and nothing of the sort.
That is come.
I have, my lord, I have a baby, my lord, 3 years baby, milk suckling baby. So to feed her, I went away, my lord. Nearby village, my lord. Now your lordship would be pleased to see page 16. Page 16, the order passed by the coordinate bench, my lord, that co-accused was arrested and he was granted bail. Now, my lord, my humble submission before your lordship, that what may be the drug, my lord, that 10.5, that is intermediate, that is not commercial, not small, my lord. And your lordship, that co-accused has been granted bail, and I am woman, my lord, having milk sucking baby, my lord. My humble submission before your lordship, as drug is already seized, my lord. So, my lord, nothing is to be recovered. I am to face the trial, no doubt. I am woman, my lord, your.
Is proven not a my lord commercial quantity, but it is recovered from her, my lord. And my lord, she was well, a habitual offender, my lord. My lord, statement taken, my lord, it is revealed from them that, my lord. Yes, my lord, occasionally people comes to her, my lord, to purchase that drugs. So he is, my lord, habitual offender. So, my lord, interim, my lord,
And I may say, no, this final disposal.
my lord.
CDS comes, so final
CDR
disposal.
come, my lord, but it is interim, my lord, I have objection.
No, it will be finally disposed of.
Man.
Here, my lord, your lordship, what my learned friends submitted, Lord, that is in CD.
I can also have a look,
My-
Mr. Sharma. I can have a look.
My lord,
I can also have a
here
look.
only one point, my lord.
Yes, please.
That I am seller and I am habitual offender, my lord. I humbly submit before your lordship with a condition put by your lordship that in future, if I am apprehended again, my lord, my bail petition may be rejected. So regarding habitual offender, my lord, no, possibly no mention that this case, that case, my lord. Mere saying that I am habitual offender, my lord. Anyhow, my lord, I am not disputing. If that is so, on condition, my lord, being a woman, my lord, having baby of 3 years, that in future, if it is found that I am again involved in this type of business,
That's true.
then my bail may be cancelled. On that condition also, my lord, that
Heard, I may say, and additional people. The petitioner Mufasina Hussain so and so invoking section 482 BNSS is seeking anticipatory bail with regard to Lahori Ghat PS case number 117 2025 under 21B NDPS Act. Investigation is in progress in this case arising out of 1/6/2025. Good stuff. Where it is alleged that 10.5 grams of suspected heroin was seized from the petitioner, and she was found trying to sell contraband in that area, and that the police operation was conducted as per information, and also with the help of another accused. Full stop. The Mr. Sheikh, learned counsel for the petitioner, submits that that with regard to the allegation that that the petitioner fled away from one home where she was kept. The petitioner with regard to this home. The petitioner denies the same, and it is also submitted that she has a minor child to look after and seeks bail. Mr. Sharma, the learned additional PP, submits that the investigation has supported the allegation of recovery of heroin/contraband from the petitioner and the materials, and that she is involved in selling of drugs, narcotic drugs, and is a habitual offender. So, the case diary has been placed before me. The statements of the witness lend support to the allegations of recovery of heroin. Upon perusing the materials, I find force in the contention that the petitioner is prima facie involved in trafficking of narcotic drugs. In the circumstances, this is not a fit case for grant of 3 years bail. which accordingly stands rejected. Return back the case diary.
Obliged.
32.
May I please, your lordship? Petitioner are already interim lordship. It was fall for lordship.
32, my lord, case diary not received. He is on interim, my lord.
No. Case diary is not received. Issue fresh reminder, issue reminder. Interim anticipatory bail granted by the order dated 7/11/25 stands extended till the next date of list. This is the matter on. Can suggested it.
No, my lord, 12.
Bail hearing BA 16.
May I please, your lordship, this is for 83 application, lordship, CD was called for. No,
Case diary is pending for some time. then.
16.
Anybody is appearing for the informant? POXO is there. So
Yes,
If the judge may appoint an
amicus.
amicus, because
Lordship,
service.
this is the fourth time CD was called.
CD
for.
has come?
Lordship,
CD has not come, but service.
let's see the last order, lordship.
Anyway.
This is the last chance given.
I am also, because the court also needs the CD without seeing the CD in a POXO case.
And POXO is not.
Service is
accepted.
complete,
There is
then
an
today
final
also
order.
we have to appoint an.
No,
someone.
that is easy part that we can do, but why the interim bail is given to two and
Lordship,
Interim is granted.
to the all the petitioners,
one petition.
One petition.
one petitioner.
Petitioner.
One petition.
Only one petitioner is there.
He has been given interim.
He is been given
And
interim.
POXO is not attractive, lordship, may kindly produce the order, lordship.
So he is
And
not
last
prejudiced manner, sir, for making such submissions.
Oh, nice. The alleged victim is not a minor.
No, maybe no, lordship.
Otherwise, this allegation, anyway, not
Yeah.
going to it, no.
And in the last order, lordship, this is the last chance given for CD.
Otherwise, it is, the court also needs the CD, since you are in interim,
Lot-
but please get the CD,
Lot-
because otherwise you will have to,
lot-
I don't like to use this coercive measures,
lot.
that personally come and all, but
Lordship, sir.
kindly instruct him,
Lordship.
because we are, she also wants the matter to be disposed of, right,
Lordship.
despite having the interim, because the uncertainty is there. Understand. Heard, see, Amit learned counsel for the petitioner. Mr. The petitioner was granted interim bail on 14/11/2025. Sorry, on 25/9/2025. With conditions and stuff. The case has been pending for the case diary for some time. At
And
the
also for notice.
stop. The petitioner, the prosecution shall take steps to ensure that the case diary is positively received by the next date. Notice upon the respond number 2/informant is complete, right? And however, none has appeared, so we have to appoint amicus. Amicus, please come. B Chaudhary, Bernita Chaudhary. Appointed as amicus. Petitioner shall furnish a copy. Kindly give a copy to her, to the amicus, and take the instructions. And let's fix it this week only. When? Friday.
Friday.
Interim bail stands extended to the next date of list. Get the CD. Oh, yeah, thanks.
28.
We'll dispose it of.
17.
Wait, please. This is a POCSO matter, matter has actually already been submitted, Lordship, and trial court record was called from the last date, Lordship, postponed, it has been received.
I received mine.
Accused is behind the bar for last 82 days. This is a relationship, intimate relationship between two young boys and girl. The girl is a minor, below 18. According to our information, she is above 16, above 17. But in the FIR, it was mentioned about 15 or 16, Lordship.
The boy is about 21 years.
21 years. He is a railway employee, Lordship.
She's a
And
minor.
matter has already been compromised, Lordship. We are ready to perform marriage, some misunderstanding. That we have to refuse the marriage because of minority only.
Obviously.
So
That's
the FIR was got
Right,
lodged, Lordship.
right. thing
I
to-
may I submit, Lordship, on agreement between the parents.
Just a minute.
Both.
Please, let us see the statement once of the girl.
Well, I have flag marked from the PCR matter, personally kindly. Several times she has been
A
raped.
copy has been given to us. Also, say, yes, that part is there, Lordship. But for last 2 years, most probably, they have got in relationship,
My stage of the stage
consenting
of copy
party.
matter.
Let me read it. Okay. She had pregnancy also.
Aborted.
Yes, it
Abortion
started
was
as
by
a
mother.
relationship. It started as a
Abortion was by
relationship.
mother.
Hmm? Yes.
It is in the last part of the statement.
What is the stage of the case?
The copy.
Copy.
The copy has been furnished, Lordship. Charge has been
Okay.
framed.
Okay.
Just On the same day, copy furnished. and
Victim may be examined, I think,
Victim maybe,
because it started as a relationship,
yes,
though she was a minor. Then there are other,
Yeah.
about forceful.
yeah, let the victim
all
be
these
examined
things,
by.
it will be better, because we don't know. She's a very she's like almost like orphan, because her father died in childhood. Her mother married 2 times and went away with someone. So very vulnerable life situation. Anyway.
Father has also, this agreement has been given as soon as she attains the age of marriageable age.
No, father, no, she is too, because sometimes, anyway, so it will be better.
Will face the trial also, otherwise our service will go also.
No. As a railway employee, he is expected to be more responsible. With a minor, law is presumed to be for everyone. Anyway,
Right.
people get into these things without realizing. You have submitted on your instructions. No issues. Escape order, Learned Counsel. And you are for the informant? Yes, sorry, I have to hear you. Sorry. Your good name, please? Yes, please, you make your submissions. I forgot to come to you.
Lordship, due some misunderstanding that FIR has been lodged against the accused person.
Mhm. Are you amicus or you have been appointed by the council, private council?
Yes.
That
Yeah, I mean, just don't mind. I mean, I'm just you've been engaged privately or amicus?
amicus.
Amicus. So yeah, there's some agreement.
Engaged counsel most probably.
Yeah, engaged council.
Engaged
That-
counsel, not amicus most probably.
Legal aid or
By the informant, Your Worship.
by the informant? Yes, that's what I said. So the informant has instructed you
Yes, Your
that
Worship.
it's a due to misunderstanding.
Due to misunderstanding that FIR has been lost.
Mm.
So now.
But otherwise, I'm not very, So do you think bail should be given at this stage, or she should be examined?
Bail should be given because we both parties agreed that the accused and the
Sir has submitted an agreement, Are you aware of that? It's my duty to ask these questions, So please don't take it otherwise. Sir has submitted an agreement. If you are aware, do you support this agreement? Because it is made by the father of the girl. Father of the girl is
Both mothers, mothers of both the parties.
mother is, very separated from her actually. She has no one actually at the moment. That is what she told the boy initially, that Gharat kun kun ase. She said, I have no one. I have nobody. Then he started becoming close to her. And he was a railway employee, a major. So
but
anyway.
at the attaining age of marriage by both the side, they will get married accordingly.
They will get married. They will get married.
Yes,
That,
Your Worship.
that is your instruction. They will marry. No, feel free. Don't feel uncomfortable. Feel free in my court. No, I mean, your instruction is that
Now
they are
is
still in a
time,
relationship.
Your Lordship.
They are still in a relationship. Are they still in a relationship with the boy?
Yes, Lordship.
They're still in a relationship.
Yes.
And they are planning to get married.
Yes,
That,
Lordship.
that you're not sure.
No, sure, I'm sure, Lordship.
Okay. And don't be nervous. Feel free. Whatever is your instruction, okay. Because this is very important, instructions from your side. So I'll record it. I'll record it. Okay. Escape order. And it takes a different dimension. The course case, it takes a different course than the course. The amicus can also take instructions, but sometimes they do not have instructions. They have to just grope in the dark and just represent the interest. That's all. If you have instructions, then it's always better. The first paragraph, okay, last order, 2410. Second paragraph is same. First up is for respondent number 2, so and so. The accused is in custody since 5/9/2025. The case has been charge sheeted upon completion of investigation and stated to be at the stage of copies. Scanned case record is available, from which I have perused statement of the girl recorded under 183 BNSS. From the statement, it reveals that though she was a minor, it started as a consensual relationship But subsequently, there are some adverse materials in that statement against the petitioner. He stated to be aged 21 years and working in the railways. Very young age is working. Huh? You know. I mean, the learned learned additional PP opposing the bail submits that the trial should progress and the victim may be the bail may be considered after examination of the victim. The petitioner side has submitted one agreement between the mother of the girl and the father,
Mother, both.
mother of the boy, about settling the issue in the context of their relationship. Ms. Tai, the learned counsel for the informant, submits that the boy and the girl are still in a relationship and they are proposing to get married, and that she also supports the agreement. The learned counsel submits that the informant has no objection to grant of bail. In the given circumstances, I deem it proper to allow the bail. Accordingly, is allowed to go on bail of 30,000 once it is like amount to the satisfaction of the concerned learned court, which is this court, special judge, Bongaigaon is, and subject to the usual conditions, no? Available for trial if one commences. Number two, hamper or temporary evidence shall not harm or harass or intimidate the victim girl. Violation will enter. Yes, bail petition stands disposed. Done.
Obliged, Lord.
Delivery of order. Bail application 2166 of 2025.
The bail petition is allowed. Sorry, please, correctly. Next.
Item number 27 of court number 24.
Oh,
May I please your lordship? My lord, sir, kindly come to the FIR. That is page 10 one. Let's hear
cattle preservation.
some local person, my lord, filed this FIR and stated here that with the inhabitant of Nimkai Ali area and informed me that last few days we have noticed in the Nimkai Ali Garu bar area moving some suspected, page 10 man,
Yes, I found it.
suspected person.
Yeah, I read it before also. Also accordingly. Who is the petitioner? He is
But his name is my lord here.
Zakir.
Zakir Ahmed. And he's a welding mechanic, my lord. And all the allegation is, my lord, false allegation. In fact, my lord, the case registered under section, my lord, 13(1) of, my lord, Cattle Preservation Act, my lord, very unfortunate. A single person cannot say that he, my lord, sell the beef and he has a slaughter. This all things is very unfortunate. How they are saying, my lord, only no proof is there.
Yes, for
Hardly
diary,
affair.
rebellion. Oh.
Statement.
Yeah, so we dispose it of.
Yes, dispose it of.
What should I say? Progress of investigation has progressed. Anyway, so no problem. Heard and did.
My lord.
Keyboard, Thakur, learned edit.
One Caesar list is
Yes,
available in the case diary, my lord.
Yes.
From the Caesar list, my lord, some suspected cow bone, my lord.
Oh, yeah, true, that's true. For 82 bail application, Sipsagar PS case number 135 under section 13(1) Cattle Preservation Act. The case arose out of an FIR dated 4/9/25 lodged by about 12 members of the public with the allegation that under the leadership of one Zakir Ali, they are noticing they're noticing illegal transport of cattle, including slaughter and selling of cow meat in the area. It is alleged that due to such activities, social environment has been damaged. Good stuff. The case diary, the Learned Counsel submits that the petitioner is not involved in the alleged offense. He's alleged to be the main person, right? The investigation has what has it revealed? The investigation, the case diary is received. It is submitted that investigation has progressed, but the chemical report regarding the nature of the meat is awaited. Full stop. There was any interim order? No. No.
No, meat was not required.
The
4-5% informant.
the given facts and circumstances, considering the progress of investigation, allowing this petition may not prejudice the investigation in any significant manner. It's such view of the matter. It is directed at it is directed that in the event of arrest, 30,000 with 1 cigarette, subject to the condition that he shall cooperate with the investigation, making himself available for examination. Number 2, not hamper or tamper with evidence, shall not violate any provisions of the Assam Cattle Preservation Act. Violation of the bail conditions make the bail liable to be cancelled.
I mobilize.
Next.
Time being item 28 of 2023, 2022. 28.
What? Also, yeah. Service is complete. Okay. None appears for the petitioner. It is submitted by the learned. Your matter?
Item 28.
Come.
I'm sorry.
No. Is submitted by the so and so.
Step I have.
The learned additional PP submits that the service upon respondent number 2 informant is not yet complete. You can take instructions, prosecution, take instructions from the concerned police station about service of notice. And scan record is available.
No, not available. But it is it is not charged, my lord.
Not charged. Call for the case diary is not yet received. Issue fresh requisition for the case diary of this Baihata Sariali PS case number 147 of 24. Okay. List the matter on. Interim bail is there. Interim granted by 19/9 stands extended till next day published. Then you can give a slightly longish date, slightly within this year only. When just
Well, my
take
lordship,
the date.
on 15th, my lord.
Date 15/12.
15/12. Interim continue.
Eighteen.
Well,
Service of notice upon the respondent number 2 was called for notice last 4 occasions.
Instruction. It's complete.
Behind the wall more than 4.5 months.
Hmm.
He is also 45%
Oh.
locomotor.
I see.
He is a disabled person.
How did he get implicated? Anyway, so Okay, record is available. It's-
Record is available, my
Mm.
lord. It can be done in
It
the.
is submitted by learned prosecution that service upon informal is complete.
Yeah.
However, as none appears, therefore, would appear, so as does Surajit Das, appointed as amicus to represent the informant. The scanned TCR is already available. Full stop. The petitioner shall furnish a copy to the amicus. Huh? You give him a copy. You can take it up. You can take it up tomorrow, or day after. Day after.
Yeah.
27. List on 27. Online. It's Das. Huh? So full name did you? Surajit Das. Yes.
This has been registered under section 22C, 25, 29 of the NDPS Act, Your
Nice.
Lordship. The FI is Lordship at page number 11, Your Lordship.
Is number 11.
Lordship. The relevant FI is page number 12, Your Lordship.
Mhm.
May I read the FIR, Your Lordship?
Yeah.
On 24/9/2025, complainant SIP Jisuma Hanoi of Nagaon PS lodged a written FIR at Nagaon PS stating that a reliable information was received from a source by the complainant at 1:50 PM on 23/9/2025. As per the information, someone was selling of illicit trafficking of narcotic drugs and psychotic substances items at nearby Nagaon area. Accordingly, the matter was informed to superior officers Nagaon. After obtaining authorization, general diary entry was made at Nagaon PS by GD number team dated 23/9/25. The police party headed by the complainant with following police personnel are detailed from town branch to assist one SIP Jisuma Hanoi. So and so. The complainant along with the detailed party along with staff proceeded towards Sokorigaon area from the PS at 2 PM. As they reach on the spot, they ambushed at Sokorigaon area. After a while, the source informed that the suspected persons were concealing NDPS in a car bearing registration number AS021292. Their staff immediately chased after the car, and although they tried to flee away, they were able to apprehend the vehicle. Following two independent persons who were found near the PO was approached by the complainant, and they were explained the purpose of search. The complainant requested them to be witness of the search, and they agreed to be witnesses. Dr. Kamal Hussain, etc. To Kamal Chandra Bora, so and so. Accordingly,
Right.
search was conducted by UBC Pranita Patar in presence of the above mentioned independent local witnesses. During such, the following items were recovered from the car bearing registration number so and so. Total 216 numbers of sparse Z plus dichlorochlorine, hydrochlorine, tramadol alternative capsules, batch number AC 2431, manufactured dated 7/25 and expired 6/27. Total 28 numbers of Judic cough syrup, batch number LPS 62508090, and so and so. Total 20 numbers of tripolidine hydrochloride codeine phosphorate syrup, dry of batch number so and so. Recovered items were seized in presence of the above mentioned witnesses. Also, preliminary test on the suspected NDPS was done with the drugs detected kits, which had shown positive result for codeine, which was done in presence of the above mentioned two independent witnesses. The whole procedure was videographed by SRF. Hence, as per the direction of OC Nagaon PS, we along with the police party seized items and accused persons. They are departed from Sokorigaon at 3 PM and returned to Nagaon PS at 3:20 PM on 23/9/2025 along with seized items and apprehended persons after medical examination. These are the
Yes.
this is the
Yeah, I've got-
case, Your Lordship.
This is the thing.
Uh,
So this is psychotropic substances. It is put in the bracket of commercial quantity.
commercial
Okay,
quantity,
okay.
but if Lordship kindly peruse the FIR. Again, if your Lordship kindly
Come to.
see the search and seizure list at page number 18 to 19, Your Lordship,
Codeine phosphate.
18 and 19, Your
Yes, sir.
Lordship.
I'm on 18 and 19.
18 to 19, Your Lordship. These are the
Mhm.
seizure list, Your Lordship, prepared by the authority, Your Lordship.
Mhm.
Again, if your Lordship kindly see the page number 23, that is magistrate order, Your Lordship.
sampling,
Something, Your Lordship.
sampling registry.
Yes, Your Lordship. The
Page-
inventory.
Page 20.
23, Your Lordship.
23.
Alexa 8 series, Your Lordship.
Mhm.
Your Lordship, 51, that is inventory.
31?
51.
Oh, mhm. No, no, inventory. Inventory.
Inventory, Lordship. 52A is the Lordship. So, Lordship, neither in the FIR, nor in the Caesar, nor in the magistrate order, nor in the inventory, Your Lordship, the weight of the drugs or psychotropic substance has mentioned, Your Lordship, in none of these documents, Your Lordship. How they classified my case or registered my case under section 22C, Your Lordship, that is not clear from this records, Your Lordship.
If it is codeine, codeine is a component of that substance,
Yes,
you know, and usually it is, in the FSL, they indicate that.
yes, but
So
the-
percent is codeine in this, but yes, prima facie, since it has a bearing on the bail matter,
Lordship,
therefore there should be some indication.
Yes,
But
but-
about we should have that chart. Do you have that, that central government notification?
Even
Actually,
in-
that we should keep, central government notification, because NDPS has to be read with that
yes,
quantity,
despite of
that
mentioning,
quantity.
yes, that despite of mentioning 2165 ZAD, Your Lordship,
Mhm.
20 cough syrup, codeine cough syrup, 28 Zodic cough syrup, Your Lordship, nothing has been mentioned in these relevant records, Your Lordship, how grams of, the quantity of cough syrup, Your Lordship, the quantity of capsules, Your Lordship. So, Your Lordship, 52, Your Lordship, 52A, that is the inventory part, Your Lordship. NDPS Act, Your Lordship, is very much clear regarding the quantity of the material, psychotic substances, Your Lordship.
Tramadol,
And even I'm relying.
metacarbonyl, codeine, two are codeine, and one is tramadol
Yes. Cough syrup and tablets, my lord.
tablets. Codeine, this tramadol is
Tramadol is 250 grams commercial quantity, Your Lordship. And small quantity is
250
5 grams,
grams.
Your
huh?
Lordship.
250 grams, tramadol. is
Yes, and
5 grams.
so 1
to
kg is commercial quantity and the small quantity is 10 gram, Your Lordship.
Tramadol
Yes, Your Lordship.
is 5 grams to 250 grams. And the codeine is,
Is 1 kg is commercial quantity, Your Lordship. And 10 gram is small quantity.
where can I find codeine? It's alphabetical. right?
Codeine is, I think, step
Alphabetical.
28,
Huh?
Just see till my.
schedule 28.
Yes, yes, I'm on the schedule only. This is C.
28,
No, it is not.
yes, 28, Your Lordship.
It's not alphabetical actually. Codeine, serial number 28. Codeine is 10 grams and 10 grams and 1 kg. So then we have to calculate that way. Tramadol. This tablet SPAS Z,
Yes.
this will have a component of tramadol.
Tramadol.
Okay. If you know the component of tramadol, then you multiply it by the number of tablets.
Tablet, there it
So
will come.
that is tramadol. And as far as codeine is concerned,
Yes.
again, you know, this hydrochloride and codeine for
Yes.
syrup,
Yes.
glycof, you know,
Yes.
these are, and Judic syrup.
Yes.
These will again have some component of codeine.
Yes, 100
So,
ml. my
So,
lord.
then you multiply by the number of bottles.
Even
number of-
11 to
Large quantity was found actually,
Yes.
quite large quantity.
quite large.
There is
11
it is a bit standardized, you know,
Yes.
this much of quantity, but I'm forgetting now.
A bottle that has not been mentioned, Your Lordship, in neither of the documents, Your Lordship. And, Your Lordship,
Is it clear from the case diary?
Yes,
Investigation?
You can do the matter once.
No, otherwise, quite a large quantity. This
Quite a large-
constitutes
Because
this much we can say, this is a quite a large quantity.
quite a large quantity.
quite a large
and
quantity.
216 tablets and Lordship will find 48 numbers of bottles, my lord.
Mm.
Even my 11 bottles form a commercial quantity, my lord. That is
11
what-
bottles.
Yes, ma'am, that comes to 1 kg, my lord, in the cough syrup, my lord.
Okay.
For the-
From where you are saying this?
Even, but
Because I also want
normally,
to
my lord,
learn.
that bottles comes in, my lord, 100 ml.
11
that
bottles
is
should
not
be,
mentioned,
Yes,
Your
that
Lordship.
is not mentioned.
That is
Ele-
not mentioned.
Even by.
from your experience, 11
yeah.
bottles is 1 kg.
Yes, because my lord, it comes with
Sir.
100 ml.
This PAS-J will not be a proper medicine. Tramadol is a opiate painkiller. It's a painkiller, but in this form, it would be a prohibited drug.
Yes, ma'am.
It's a painkiller otherwise, as far as I know.
And if we calculate the whole thing, ma'am, then it will come, my lord.
Anyway,
If it's required, my
let
lord.
us see the
I can-
materials.
I can calculate, my lord, what
Mhm.
has been found, ma'am.
Otherwise, neither of the documents has mentioned the quality,
But they are-
your lordship. Otherwise, we cannot presume in this way 100 ml, 10 ml, your lordship.
Investigation is completed?
To
No,
the,
my lord, investigation, FSL is awaited, my lord.
Yes,
And
so
so
FSL
that
is awaited.
That will throw light on the every prospect, my lord.
Mhm. Yes.
Yes, lordship, drawing from the sample,
And,
your lordship.
so far the
will-
materials are concerned, it is from the conscious position of the petitioners, my lord.
Yes,
And
yes.
it
Then
was supported
there are
by-
materials.
I have seen the seizure witnesses, their version also, my lord.
They've
They have
supported.
supported.
And your lordship,
Yes.
the suspect, your lordship. Your lordship, one of the
We
Rajasthan.
can dispose it of at this stage, keeping open the question on 37. Or we can keep it pending. We can keep
Yes.
it pending for the FSL report.
Yes.
Otherwise.
You show me that. Please.
Yes, yes, lordship.
walked-
One more ground, this I'm
Third,
taking,
let me see.
I'm taking one more ground, your lordship.
Yes.
In this case, your lordship. Because your lordship, you kindly come to 47 and 48 notices, your lordship.
Now there is no excuse, at this arrest of this today's times, in the present, they have to, grounds of arrest, 47,
It's not
40
lordship, not ground of arrest, your lordship.
Withdraw.
It is reason of arrest, your lordship.
reason
Lordship.
of arrest.
So it is very much clear
Please.
in your lordship.
Grounds of arrest have been given.
Yes, yes, it is given
Because-
in the language. they
No, it's
understand.
not in language, your lordship. But your lordship, that is Prabir Purkashta case is very much clear in this regard, your lordship. 49 paragraph, your lordship. Pending it, your lordship.
It has been given in Assamese language.
Assamese language, but the not details, brief fact of the case has been provided to me.
47 is not there. No,
47 is there, your lordship, at
It's
page
there.
number 33, your lordship, the Varnicula, your lordship. And phase number 32 is the type copy, your lordship. 33 is the Varnicula, your lordship.
No, same. no.
Here, your lordship, there is some reason of arrest, not ground of arrest, your lordship. Because it has been written, আপুনি নৱপ্ৰজন্মৰ মাজত অবৈধ নিষিদ্ধ সামগ্ৰী পৰিবহন কামত জড়িত. These are the case, your lordship, these are not even allegation level against me, your lordship.
থকা
Yeah,
স্বীকাৰ কৰে যদি আপুনি গ্ৰেপ্তাৰ কৰা নহয় তেন্তে আপুনি পলায়ন কৰিব পাৰে যদি আপোনাক গ্ৰেপ্তাৰ
6
কৰা নহয়
points are
তেন্তে
given, my
আপুনি
lord, that indicate
প্ৰমাণ
the
হ'ব।
ground.
I think I beg to differ. I think this should be specific to the person.
Where
Because Prabir
Actually,
Purkashta case is very much clear in this
in the
regard, your lordship.
second, third, you'll also be fine.
Almost same. Anyway, sure, this,
Yeah,
which
49.
judgment you want to
Yeah,
rely on? This?
Prabir Purkashta
or
49
that?
paragraph, your lordship.
No,
Provide.
we know already. Can I have a look at the diary?
Judgment, your lordship.
This judgment two weeks. 48.
49, your lordship.
This we have learned from this judgment that there is a distinction. Earlier, all of us, we had used it interchangeably, right? So now we know this is different. Reasons are generic,
Lordship.
to prevent you from tampering with evidence. This will be a generic ground.
Lordship, lordship.
And, to prevent you from, influencing the informant, this will, in this situation, this would be a specific ground, something like that. Anyway. So let me dispose it of.
Your Lordship, 2 or 3 more, this one I'm relying on regarding the weight discrepancies in the weight, Your Lordship.
You can give me. No, I go on. Please, you submit.
Lordship.
But as we know, neutral substance has to be, it has to be counted
Yes.
nowadays.
No,
There was a judgment which
Harassing-
has said it is.
Harassing judgment is there,
Then
Your Lordship.
Michael Raj,
Yes, Lordship.
and Michael Raj was overruled in harassing.
Harassing, Lordship.
It was a very important judgment. Harassing.
Your Lordship,
Something,
yes,
something.
Your Lordship. It was 2022 Supreme Raj 153 Rajasthan High Court judgment, Your Lordship. The court decision was based on the flaws in the prosecution case, including discrepancies in the weight of the seized contraband and inconsistencies in the statements, leading to the conclusion of over implication of the petitioner. And thereby bail was granted, Your Lordship, in this case, Your Lordship. Paragraph number 8, I'm relying on, Your Lordship, in this case.
Para 8.
It
Yes,
is 2024.
para,
Supreme-
are you sure it's para 8 of the Rajasthan High Court?
Yes, Lordship.
Hmm.
The relevant portion is there, Your Lordship. Paragraph
It
number
is
8.
pertinent to its claim by the witness recovered some documents like, it starts like this. You have marked para 10.
No, it was,
Instituting officers not complied with the mandate of influence of.
no, it was against judgment, Your Lordship.
Uh-huh.
It was 10, 11, 13, 14, what the Lordship is going through. That is 10, 11, 13 and 14. It was about 37 Raigad will not come if the prosecution fault is there, Lordship. So that is I'm providing, Your Lordship, 10, 11, 13 and 14, Your Lordship, the relevant paragraph, Your Lordship. Regarding the weight, Your Lordship, discrepancies of weight, Your Lordship. Non-completion of 52, Your Lordship, of NDPS Act, Your Lordship. The ND 52 is very much clear regarding the quantity also, Your Lordship. That has not been complied with in this case, Your Lordship.
The final quantity which comes in the against the person accused is the quantity after it is certified by the magistrate. Right. But in this case, we can have a broad calculation, but the exact thing will come after the FSL report.
And if we take the broad calculation, then it will.
Should
come-
we
Your
keep it,
Lordship,
should we keep it pending? Because at the moment, I'm not finding sufficient materials to grant bail because they were caught almost red-handed. Even if we are not absolutely sure whether the bracket of the quantity, but it's to the layman eye, it's quite a big.
Prima
quantity,
facie, it's-
Though we have not seen.
prima
the
facie,
credibility of the case has been already, Lordship, the root of the case, because the weight, Your Lordship, the measurement of the contraband is very much essential. in
See,
every
suppose
case,
the beneficial
Your
interpretation is also
Lordship,
given.
it is open up
When were they arrested?
road, Your Lordship.
Before 9.
Yes, 20.
10. 4/11.
Yes. 63 days.
At
behind the-
this we have to go by the section unless there is something, we cannot say that it is not commercial quantity. No? That also cannot be said definitively. So we have two options. In my opinion, I don't think sufficient grounds to, because they were,
Your Lordship, keep
you
it
can
open.
file another one later. No point keeping it pending. I think
No
let us
point keeping
dispose
it.
it off.
Right.
Otherwise, Your Lordship, the discrepancies in the.
That will become clear, madam,
Your
after.
Lordship, and the.
For
ground-
after the FSL report, it will become clear.
Then Lordship may kindly fix it for FSL report, Your Lordship, with due respect, Your.
That can take its, yeah, that maybe, that much relief I can give you. Yes. Yes.
Clarify, Your Lordship, that, Lordship.
Fair enough.
Only one pair, my lord. In that case, my lord, Lordship may kindly give us the liberty, my lord, to at least update the CD so that.
Yes, CD will go back.
Yes, because it is required for the
CD,
investigation.
CD will go back and you can even take instructions
Yes.
that what is your, about the quantity.
Yes.
That we were not sure,
Yes.
not very sure. The council had also submitted, so you make it, throw some light on it. The heard G. Bora and learned additional people. Invoking 483, the two petitioners herein were seeking regular bail in connection with Nagaon PSK 761 of 25 under section so and so. They were arrested on 24/9/2025. The allegations in a very nutshell that psychotropic substances by way of cough syrups containing codeine, suspected codeine, and SPSZ tablets containing tramadol were seized from them. The penal provision given pertains to commercial quantity, that is 22C. Full stop. The learned counsel makes a contention regarding the grounds of arrest. I perused the notices, copy of the notices under 4740 next to the petition. Prima facie, I do not find any fatal non-compliance with the said statutory provisions in terms of the governing law vis-a-vis Article 22(1) of the Constitution of India. Full stop. The case diary has been received. Learned additional PP submits that there are sufficient incriminating materials, and the seizure witnesses have also supported the seizure. Nevertheless, FSL report is said to be awaited, and the learned counsel also submits that on the basis of the existing materials, the quantity of the prohibited psychotropic substance is not clear, and as to whether it falls in the bracket of commercial quantity. Full stop. As the FSL report is awaited, and such report is expected to make clear the question of quantity. Therefore, the bail petition is kept pending, return back the case there, and to be procured again along with updated investigation, an updated investigation, and the FSL report. Okay. This will go back.
Yes,
Then you
but
can
11 I will.
take back the judgments.
Yes.
This is Bora. Take back the judgments. You will need these judgments. And you can submit it again. I'll leave it to both of you.
Yes, because
I'll
if
leave
we
it to
send
both of
back-
you.
We send back matter, then
16th or 18th,
Fifth,
just
yeah.
before vacation.
7 mile will not serve the purpose. 15th mile.
Alrighty, well, you can take it.
20.
May I please your lordship? Lordship, here on the last occasion, Mr. Service was complete, my lordship.
Foxo matter.
A Foxo matter, my lordship.
Service was complete.
My lordship. My lordship, here in this case, my lordship may be pleased to appoint an amicus, my lordship. Because they are not appearing. And my lordship, I have another fear that my lordship, I have already brought the evidences of the PW 1 and 2, which say,
21.
my lordship, here is
This is also yours.
the same, my lordship. My lordship, here also the amicus.
Which is complete, my lord. CD also we received, so lordship can fix
Can
a
it-
short date.
And the other one was a CD case diary.
Other one is
Case record.
Case
Case
record.
record.
Case record.
It's your.
My lordship,
I got it. TCR is available. Yes, tell me.
My lordship, here also can it be fixed on day after tomorrow? Because why, my lordship? Because it is under 14 and 15, and my lordship, actually by the case nature, it falls under 14 subsection 1, and he's already in 73 days.
Alright. So your matter, both our matters are yours, so we'll fix it together. No problem. Amicus, again, fix, integrate. Amicus.
If my minor daughter so and so, without her consent, by trapping her in love affair and refusing to marry her as a result of which she got pregnant. When the firm came to know about that, it was assured that marriage would be performed with the accused number 1 I am not accused number one, my lord. After attending the appropriate age of my daughter, thereby aborting my daughter's pregnancy and physical relation was continued to be made. But only a few days back, accused number two, I am, my lord, my allegation against me, conspiringly took the accused number one to an unknown place and got him married with another girl and has kept him hidden. This is the allegation against me.
Here, my lord, we have received the CD, but the service is not complete, my lord, regarding the notice part.
Is it POXO?
Also,
So moreover, your lordship, notice under section 47 and 48, it is in English, your lordship. I am illiterate person, your lordship. Thumb impression is given, page 18, your lordship. And 19, your lordship, left hand side, accused thumb impression is there. My lord, since my lord, he is behind the bar, so infringe your lordship, maybe give. There is no allegation, my lord. I have found, my lord, there is no offense has been made out against me. Whatever the allegation, it is against my son.
This service, you can take instructions. Can you
Yes.
take instructions? Girl is not missing, no? He's there.
No, it is not. Not missing. My lord. Only allegation is this,
Yes.
that I kept my son to some other place and
Because he did not have his consent.
may please allow. But this is a regular bail application. Also, will kindly see page number 12. The petitioner, my lord, sub-inspector of police.
Some Assam Police Act.
Yes, he, my lord, was a sub-inspector of police, my lord.
A page, which page?
Page 12, my lord.
12.
12.
Okay.
And before this incident,
Mhm.
he was working
SI.
as the officer in charge of Tamarhat police station,
In Dhubri.
Dhubri. Then what happened, my lord, on 28/9/2025, he received an information that 3 boys had entered the house of one Habibul Sheikh
Mm.
and were demanding money. So he sent a police party, the boys were picked up.
Mm.
And subsequently, the boys informed him that Habibul Sheikh owed some money.
Mm.
So he instructed that you come and file an FIR and we'll take action. So after that, they will let go. These 3 boys, after on peer bond, after doing medical test, my lord. On the next day, my lord, these 3 boys returned and one of them lodged an FIR, my lord. This FIR, my lord, is at page number 13.
Okay. I've
On
not
20
followed fully actually. What happened? That Habibur Sheikh.
Habibul Sheikh.
Let us read it then. We can read
Yes,
that.
well,
right?
Habibul
Ah.
Sheikh gave an information that
Hmm.
3 boys,
3 boys were.
3 boys came to his house and were demanding money
Okay.
to the petitioner. Petitioner was the OC of Tamarhat police station. So he received that information.
Hmm.
So immediately he sent a police team
Hmm.
and picked these 3 boys.
Hmm.
Thereafter, my lord, he instructed that you lodge an FIR against Habibul Sheikh if Habibul Sheikh owed some money.
Hmm.
They said that there was some monetary transaction. So he said that you lodge an FIR and we'll take action. So on the next day,
Hmm.
one of these 3 boys, that is Rakesh Roy, he lost this FIR on 29/9/2025 against this Habibul Sheikh.
Hmm.
Thereafter, Habibul Sheikh was arrested. Now, what happened after 2 days, my lord? Out of these 3 boys,
Hmm.
one Monohari Rai, he died under mysterious circumstances. And the locals alleged that that was a result of custodial torture.
Hmm.
So some organizations, by the local public, they lodged an FIR against the present petitioner who was working as the officer in charge. These FIR, my lord, will find it, page number 24. And the translated part is at page number 19.
Mhm.
19.
Let us read this.
Yes.
Diary has come. It's
That is coming.
okay.
With due respect, I beg to mention that on 28/9/2025,
Wait, just a minute.
yes, at page number 9,
Page number
19, 19.
19.
19.
Yes.
19.
Informant Biren Roy.
Biren Roy.
Oh.
With due respect, I beg to mention that on 28/9/2025 at around 7:30 p.m., my son's friends Rakesh Roy, Ganesh Roy, along with my son Monohari Roy, together went to demand rupees 21,000 from Habibul Sheikh of Dingdinga village and after entering his house, found Habibul Sheikh's father, Zolil Sheikh, and when they asked about the money taken by Habibul Sheikh, Zolil Sheikh abused the three of them using obscene language and also behaved erratically and immediately informed his son, Habibul Sheikh, over phone. Later, Habibul Sheikh, after knowing about this incident, immediately informed Kopil Bora, officer in charge, Tamarhat police station, following which, as per the directions of Kopil Bora, officer in charge, Tamarhat PS, a police party from the police station, nabbed all three of them, including my son, and brought them to Kopil Bora, OC Tamarhat PS. After that, Kopil Bora hit all three of them with bamboo sticks, brutally causing serious injuries on various parts of their body. Later on, all three were sent to MPHC. So, my lord, it was after the incident. They were sent to MPHC Tamarhat for medical examination and were threatened not to divulge about the incident before the doctor and any person. After the test, the three boys along with my son were handed over to their respective guardians. Later on, my boy Monohari Rai became sick in the house, following which, while bringing him from treatment to Tamarhat MPHC, he died during transit. It is to be mentioned that as I was busy with my son's cremation and was grieving because of my son's death, there was a delay in lodging the FIR. The FIR, my lord, was registered under 117, that is grievous heart, my lord, 105, culpable homicide not amounting to murder, and 98A, 99(5) of the Assam Police
Police
Act.
Act.
These are minor sections, my lord.
Regarding some,
Regarding, my lord,
I'm not familiar.
my lord, not following the courts of law. It's like that, my lord, regarding 98 and 99.
He was arrested.
He was, my lord, arrested on 8,
I see.
8, 10.
Oh.
And he, till date, my lord, he has completed 48 days.
He is a SI of police.
Yes, sir. 48 days in custody, my lord. Now, basically, the allegation was of custodial torture. But my instruction is that, my lord, this deceased, he was already suffering from various ailments, my lord, including liver diseases, my lord. And the death was caused because of that. And if your lordship will see, there is a gap of around 2-3 days between the date of death and the date when they were picked up by the police. So, the postmortem report will make it everything clear, the medical report. If there are no external injuries, no internal injuries, definitely these sections will, privacy will not be attracted, man.
Yeah. Could you go through the case diary?
Well, I have already done, my lord. So, my lord, postmortem report says, my lord, there is no any external injury. And my lord, it was opinion, my lord, that it is a still till pen receipt of the, my lord, chemical analysis report. Chemical analysis report, my lord, also, my lord, in the part of the case there, my lord. This said, my lord, that gave positive test for carbonate insecticide. No poison was detected. And my lord, the doctor's statement was also, my lord, recorded. According to him, my lord, I will place it before your lordship. My lord, that some liver infection was already there. The patient of, in case of my lord, Monohari Rai. And my lord, the statement of my lord, other two persons, my lord, who were along with him, my lord, the disease, my lord. Their statement, my lord, something, my lord, different. Regarding, my lord, assault, there is no mention. And I am placing it before your lordship.
Might have to be studied properly.
But apparently, my lord,
Let me keep it for the chamber.
My lord.
And study, I'll have to see it properly. I'll give it back today only and hopefully.
Please, my lord.
And
And the
you're
next,
going to complete your submission. Yes.
yes. And another thing is that, my lord,
Contradictory statements of the other, pro-victims in a way.
co-victims, my lord.
another thing is that, my lord, length of detention. He's a government servant, my lord. He has already, my lord, completed 48 days behind bars, my lord. So most of the investigation has already been completed, my lord. So perhaps further custodial detention may not be required for the purpose of investigation. My lord. That is one ground. My lord. Another thing is that, my lord, regarding the non-receipt of the 48 notice, my lord. So, though my lord, the 40th notice is was my lord placed in the record, my lord, but my lord, none of his family members received any copy of the 40th notice, my lord. Because his my lord, only mother, my lord, she stays in Tezpur, my lord. So she did not receive any 40th notice, my lord. And because of which, my lord, no bail application could be moved on the first day, my lord.
Mm.
I have annexed the order. The order is at my lord, page number 35.
Right.
The first remand order, my lord.
Mhm.
No bail application was moved. So from the, my lord, what the learned PP has submitted, my lord, prima facie, my lord, it does not show that there was any ingredient.
Yes,
of
because it
custodial
should
torture.
reflect in the postmortem report.
Yes,
Well,
Of course, you cannot assume that postmortem report was not done properly.
Yes.
It has to be assumed that
yes,
it is done properly, but
Yes.
this kind of abdominal or whatever injuries causing death
yes,
should have, it should come in the PM report.
yes.
It
And
should
Lord
come.
will also examine
Cause
the-
of death, weight,
reports
multiple
on the date of the incident.
consistency, semi-solid materials.
my lord, in the liver column, my lord, that
Uh,
the PM, something is, my lord.
He's found to be suffering from alcoholic cirrhosis.
Yes, man, that perhaps that is the.
But it is possible that actually he was already having a fragile health condition,
Yes.
but he was not fatally beaten, but beaten to some extent, and then he
Yes.
died.
That, my lord, that Lordship will also see
Hmm.
at in the first FIR, my lord, which day, Lord, my lord.
But
At,
if someone has to die only from an assault, then it has to show.
Yes.
It has to show.
And the medical reports, my lord, which were done, my lord, on the very first day, those reports also do not indicate the presence of any external injury.
I'll see probably. So I'm thinking some
My lord, the statement of other two person.
are contradictory.
Yes, man.
But because they all, nothing funny about it, but all of them were supposed to have been beaten together. So,
Yes.
but it should have come anyway.
And on the
So,
next day, they voluntarily came
Oh.
and lodged the first FIR.
Let me see.
Yes.
Properly.
Right.
Temporarily.
Highly obliged.
Admission, I think.
Admission. Admission matters.
Yeah, so in this case, I am on behalf of the Jai Quality Trust.
Yeah,
Mr. Jai Kolita.
yes.
The petition filed for quashing of the order dated 24/2025, passed in the petition dated petition number 319/25 in the NICI case number 130/2024. The impugn order is at page 39.
What is NICR?
NICI is a negotiable instrument like
Oh, sir, NIC.
NICI.
NIC.
NICI. Whatever the petitioner had taken loan from the respondent number 2. Initially, actually, she taken rupees 1 lakh, and she already refunded 80,000. He failed to refund 20,000, but as a security, he has hand over 3 blank check and some papers lawsuit. After that, and regarding this lawsuit, he filed complaint before that.
Just
also lawsuit.
record is coming. Record is
What has
coming.
called for lawsuit?
Record is coming.
I am appearing for respondent number 2, my lord.
Yes, the complainant.
Yes, my lord.
Complainant.
We need some time, my lord, to file, my lord, affidavit, my lord, since we have received the copy today itself, my lord.
Today, no, we should say, sorry.
I've taken up the matter, I mean, may or may not be possible to dispose at the stage of admission, not necessarily today or another day. But should I admit it? Or because we are in
1 lakh has been
we are
taken
in a fix actually, because admission councils don't prefer usually because they think it may get delayed in the hearing queue. But all matters may not be possible to be disposed of at the stage of admission, right? If it is possible, it should be definitely disposed of. Yeah, please. What do you say? You're saying something?
Also, the petitioner has taken only rupees 1 lakh. I have stated in paragraph 3 also.
So if I've understood you correctly, there is no debt. There is no
1 lakh
debt to be returned back or partly returned.
20,000 is debt loss.
Only 20,000 is
Right now.
left.
But at the time of the taking loan lawsuit, he hand over 3 blank checks
Hmm.
and some blank papers
Hmm.
and Aadhaar card and PAN card also. After that,
When the case was filed, if that is true, if before filing the, whatever little I know, as for at the time of filing the complaint, if only 20,000 is left, only to that extent the complaint has to be filed, only to that extent. But that is the details have to be seen, what is the facts. But anyway, let them
they can file a
file
suit.
the-
Till then also can instead of proceeding us. In last occasion already there's ordered that after receipt of the LCR, which matter may be interim matter may be passed also.
My lord, what has happened, my lord? The contesting counsel, my lord, he is not available, my lord. He has handed me the brief to take some time from the
He
court.
informed me also, he went to the airport also.
till next day, stay.
Till next day also.
Learned counsel.
NJ Gogoi on behalf of.
Yeah, no problem. On your own, only. Learned counsel appears on behalf of the petitioner. I will not record any submissions on the merits. So the case record has been received, scan case record has been received. The respondent slash complainant, respondent number 2 / complainant has entered appearance to learned counsel.
SS Ahmed, my lord.
SS Ahmed. You are newly engaged, right? So who submits that being newly engaged?
Anyways,
Oh.
on the way to airport, few
He
people.
was contesting, my lord. He is not available.
Okay,
Sir AM Ahmed.
okay. Stop, and the learned counsel seek some time to file you'll file an objection, affidavit. You'll file a reply. Stop, the prayer is allowed, when should, after, till the next date of listing, further proceedings in, what is the case number?
Case number NICR one, case number.
Now it is, CIS, it is registered as NICR.
NICR 136 of 2024.
NICR.
Pending
Complaint case.
extra CGM. Bongaigaon.
NICR case number 136 of 20. Pending before learned CJM Bongaigaon.
Bongaigaon.
Shall remain state. You mutually work out a date. Let me know.
So any.
But then
First week of December.
take it in second week, my opinion.
That's it.
Hmm.
On 15 or 16, I did. Hold on.
16, 16, 16, 12.
God bless.
Pancham books.
13.
Wait, please, your lordship. As per office dated 21/11/2025, the scanned copy of the TCR has not been received. The matter was about Jimma of a rice. Lordship may fix for a short date.
Scan record has not been received. Yes. As submitted by the learned counsel, office note dated 21/11/2025 indicates that case number, case record has not yet been received of PRC number 456 of 25. Issue fresh reminder?
Yes.
Reminder for that. Up to date JIMA report has not been called for. We have to examine at that time. Otherwise, you can always prefer another one before the trial, you know, because of up to date. If it's a revision, you have to mainly confine to the correctness of that order. Anyway. So. Leave the matter on. Where did I fix it? Date.
On my lord, 9th of December.
Okay. 9/12.
Much obliged.
14.
Before I.
Right, Mr. Lordship. Lordship, here we have challenged the proceeding, a child marriage case, my lord. My lord, here the petitioners are joint petition husband and wife, my lord, there. And they have also a child, 2 years. My lord, our High Court already decided, so many orders have been passed and caused the proceedings, my lord. So, my lord, I think last occasion I have also submitted order
Yeah, I think
It's
there's
already decided, my lord. So many orders have been passed.
some of these may be reported cases also. No?
Oh,
It's
my
not
lord.
reported. Should be reported.
My lord.
That's it.
Interim is also there. So my lord, maybe you disposed of, my lord. Because in terms of order, I have also annexed
Yeah,
one.
I recorded the submission, informant of the informant side that you have no objection. No objection. They are living together now.
Living together, husband and wife.
Also having a
Child
child.
also.
Just give me. I'll have a look at this order. Those-
Child of 2 years, my lord.
I would like to have a look at the agreement.
My lord.
You have an agreement.
Agreement, that is last page, my lord. Page 39. I am also submitting before my one order. Same issue, my lord, says already.
The informant is the VDP secretary. Okay. So, any problem in that victim? You must have some instruction. No? You have been privately engaged. Privately engaged. So you have some instruction from the victim's family also. This is another decision. No. Similar lines.
Similar line. I have also annexed one also, my lord.
Going strictly by the language of Narinder Singh, maybe POCSO may not come, but this is a different case. Actually, it falls somewhere in between child marriage and then they're marrying together,
But
staying
here,
together.
both are married and they are having a child of 2 years, my lord. Considering the future of child also, my lord.
Okay, please sit down. I'll heard last order, first paragraph will be said. Short order, you will dispose it of. Sit down, sit down. You're Mr. Hawk, huh?
Yes, I am appearing on behalf.
Informant is. Informant victim. Additional PP Botako. এইটো নিচিনা আপুনি ল'ব পাৰে বস্তু similar হ'ব বস্তু Also, both have filed the petitions together.
Together.
Oh. The two petitioners herein stated to be husband and wife, namely Faridul Islam and Azmina Khatun. have jointly invoked the jurisdiction under 528 BNSS, seeking quashing of the entire criminal proceedings of dash D, special POCSO case number 118 of 24, comma, arising out of Mankasar PS case number 84 of 23, under section 9, 10, 11 of Prohibition of Child Marriage Act, read with section 6/17 of the POCSO Act. Full stop. The said case is stated to be pending before the learned special judge South Salmara.
Midway 24.
Please, Your Lordship. If mistake has been taken through paper publication.
Just do what is come for. Let- What is the, it's a criminal petition.
Yes.
Just to see.
My lord, in additional affidavit, annexure number 7
Mhm.
has been wrongly annexed here.
Oh.
Kindly allow me to correct the annexure.
How will you correct it? How it has to be corrected? Which one? IA has to be 5. I'm asking,
Affidavit or annexure one.
if it has gone into the CIS, then you'll have to file a IA probably.
You will have to file
Hmm?
again one.
I'm seeking your guidance. To correct it, but
Yes.
how it has to be corrected?
He has made one paper publication.
Yes,
Same newspaper.
paper publication is done. Done.
Yes, yes.
He will have to again file one additional affidavit by annexing the correct document.
Is it? Okay.
Paper publication. Because
Okay.
he cannot correct in this.
Yeah, it has gone into CIS.
Yes. He will have to.
So this affidavit was regarding paper publication. I see.
Proceedings already state manually on 26/23 long day.
Is okay, peruse the last order dated 15/10/2025. It is submitted, Mr. Bhuya, yeah,
No, TT Money on behalf of M. Khan.
Learned Council submits that paper publication / substituted service has been resorted to. But what happens to the earlier affidavit?
Earlier affidavit.
He has already filed it.
He has already filed that,
Uh.
it's also a part of the record.
Though, and has been resorted to, and though a compliance affidavit has been filed, but some errors crept in, and he seeks permission to file a corrected affidavit. Where is allowed. And what else? This was also the steps was also taken through the jurisdictional PS. You took some instruction.
Yes, I'll try to get it.
The prosecution may also try to seek instructions regarding.
You get to serve the copy of the same for onward transmission to the police station. Man.
Okay. So I'll take instructions from the jurisdictional PS regarding service, comma, for which the petitioner shall serve a copy to the learned additional PP. Why bail? You're challenging.
For crossing of the FIR and short sheet. No? Already scan copy received. Scan copy of TCR.
The scanned case record has also already been received. So you file the affidavit, and after it is, and then let's see what can be done. When you take instruction, if it comes, the respond number 2 is the informant.
Yes.
Oh.
Informant.
Army personnel. The interim order dated B26 206 shall continue till the next date of list. List on.
List on 16th of December, 16, 12.
16 12.
Okay.
34.
Actually, as per service report, service on responded number 2 is not completed yet. That we have obtained the back report.
File PowerPoint. Yes.
You have appeared?
Okay.
Okay. That solves your problem, isn't it? So this is a revision against conviction.
Revision, actually I was acquitted, but again, it was remanded back for retrial. That I have challenged by way of this revision.
Okay. Acquitted and remand. You are challenging that appellate
The
order.
remanded
Appellate order which remanded
back
and for retrial.
retrial. On the ground that the evidence which was adduced, it was a photocopy. The forged document, a photocopy was adduced in the
Anyway.
trial.
Okay.
That's the issue.
The original GR, original record.
Original record.
The original case record of PRC 162 of 2020, within bracket GR 1893 of 2019 has been received from the learned court below. Stop. Learned counsel appears, enters appearance. You file wakalat, no? Enters appearance on behalf of respond number 2. Respond number 2, informant. Stop. So it is ready that way for hearing. That means, should I admit it?
Let it come up for admission.
We need a solution to this. So some matters have to come for a hearing. Right?
Yeah.
Some
But
matters have to come.
in
For
my
these
case-
will require.
Because of
See, the thing is that, in my humble opinion, only matters where you can see this much is hearing. Suppose with this much you can dispose of the matter, then it can be disposed of at admission. But full hearing,
Yes.
if you conduct, that means that is little unfair to the hearing matters. But that is not actually the problem of the councils. That is, we have to some things in make another streamline some processes so that the hearings reach. Anyway, so let it remain the stage of admission only. Then it has come for orders. It has not been admitted.
Not.
List on so and so that in the admission column.
Admission column. Here, her pensionary benefit is stuck because of.
That's because of this. Date. You work out a date, both of you. More than the PP.
16 December.
don't fix too many matters before the vacation, because we have a lot of new matters coming up. Bails will be filed, many urgent matters will be filed. So, okay, let it be 16th only.
16.
Yeah,
And if I-
otherwise, get clogged otherwise
Much of.
last week.
Lots of steps has been taken. This time was not received. Instruction.
I will get the instruction postpone.
What is there? IA, right?
IA, an application under section 5 of the delay of 929 days in connected appeal or earlier was stated in order dated 24/6/25, Lordship, I have taken fresh step
Mhm,
in upon respondent number 2.
mhm.
Notice has been not come.
Notice has not come. He must be in custody, right? This, now we'll complete the process, but just asking, Mr. Bodagu, this, noticing the informant will be necessary in delay condonation criminal appeal also. This kind of first criminal appeal against conviction. There's only one criminal appeal in the High Court. But it's
May
always
not be
better, always better. But yeah. The interlocutory application is for condonation of delay of 929 days in preferring an appeal. An appeal against judgment of conviction and sentence in special POCSO case number 1 of 2019 from the Court of Learned Additional Session Judge Bozali, Atsal. Stop. The service upon respondent number 2 is 2/informant is pending. So what will you do? Instructions?
For my lord, in case of criminal appeal, that is not at all mandatory, man.
Criminal appeal. But anyway, since now what?
Only otherwise, my lord, right now only notice has been issued, man.
Hmm.
Only for the purpose of delay.
Now actually victimology has progressed to some extent, to the extent that there's a judgment also, I don't remember the name, that the victim has to be given a say in the system all the way from bail to this thing. Hmm. So increasingly, we cannot go back actually. Now, more and more matters, this will be necessary. Because, but the only thing we have to guard against is that the matters don't get delayed for that process. Anyway, so can you take instructions like bail matter?
Postpone. My lord, here, delay not yet, my notice.
Yes.
Delay is not yet conducted. No, criminal appeal is not for criminal appeal. Criminal appeal actually it is not yet born in a way. So it's numbered or not numbered. It is numbered, but not yet. But it's 24 criminal appeal. This must be taking a lot of time then. Anyway, will you take instructions from the concerned regarding service?
Yes. Yeah, my lord, I will get that.
No, what else? Should she take fresh steps?
Then, my lord, she will have to take steps through office of the public.
Would you like to take fresh steps? You can suggest me what would be the best course of action.
That will, my lord, otherwise matter will be unnecessarily delayed. I will get the instruction, my lord, if she can take steps. My lord.
Okay. The appellant side shall take fresh steps upon steps of notice upon R2 to the office of the public prosecutor, which can do the needful. Right? Like that? List on.
December past week.
Let it be on. Eight.
Steps did one.
36.
Wait, please, your lord. Lordship, in this matter, if your lordship peruses the order dated 26/6/2025, my interim prayer was to be considered on the subsequent date, But like-
26?
26/6/2025. But due to certain exigencies, Lordship, it has not yet been considered.
Okay, I'll have a look.
The last line, Lordship.
I understand.
What is negative or returnable of interim to consider according to the question?
You wanted to be discharged, but it was not allowed.
Yes, it was not allowed, Lordship. It is. The Lordship wants.
Just.
to-
Scan record has come.
Yes.
Record has come. This.
Service is not complete on.
Oh.
I have taken fresh step.
Today, matter is listed for orders regarding service only.
Right.
The next date on the trial court is fixed on 28th of this month.
To 28,
Yes.
Friday.
Yes. Lord.
Hmm. What is the, you have taken steps?
Yes, I have taken fresh steps also on the last occasion.
Sure.
The earlier was said that the addressee was not found, unserved
Mm-hmm.
notice came back. So I have taken fresh steps on the last occasion and it says the service report is still awaited, Lord. I have checked the office note also. But the TCR is received, Lordship.
Mhm.
So
Case diary it was called for.
yes,
Case
the
diary
up to date
must have
case
come.
diary, that is also.
Volume of case.
Yes, volume. Yes.
Service report is awaited. So you will await the service report or we have to wait, right?
If your Lordship, I'll just like to I'll just like to show your Lordship the FIR.
Okay.
Just a few statements I have annexed, the 161 statements. I am on the very limited scope, Lordship. The FIR is totally contradictory to whatever the police have said, these statements recorded by the police. So it doesn't give rise to Lordship grave suspicion, Lordship.
You sought discharge for some of the sections or
No,
complete
the
discharge?
entire.
Complete discharge.
Yes, Lordship. Yes.
Okay, then let us go do some limited studies.
Yes, Lordship, just.
You
Because
can take.
they are all brothers, Lordship. The informant and the petitioners before your Lordship, they're brothers, they reside on the same compound.
Okay.
And the
You can
district-
take me to the relevant
Yes, the
matrix
Lordship
to
will
decide the
FIR
question of interest.
Yes, Lordship, the FIR is at page 32, the translated copy, translated type copy. The vernacular is in Hindi, next to is 33. I'll just tell the gist of the FIR, Lordship. The informant alleged that the water from my terrace used to fall on his house. And for that reason, his minor child used to get scared. When he came to inform that to our house, then we assaulted him. And as per the FIR, he suffered serious injuries, Lordship. His teeth were broken and his spinal waist bone was also broken, Lordship. So this is what has been stated in the FIR.
Right.
So 3 persons were named in the FIR. 2 persons are before your Lordship. The other is the mother. She has been, the final report has been filed against her. So the trial court didn't proceed against
Charge
her.
sheet was under 325/506.
Yes, same section. Same section, Lordship. So now I just want to say that they say that I assaulted, but one of the 4 witnesses are examined by the police. 161 statements were recorded, Lordship. The first one was, Lordship may come to page 35. The first one is the complainant himself. He has basically reiterated what he has stated in the FIR. The next one is an independent witness. Lordship may just come to page 38 by the name of Nandan Sharma. Here this doubt creeps in, Lordship. This person has stated 38 is the translated copy and 39 is the vernacular, Lordship. Here this witness has stated that, if I may read it, Lordship.
Yes, I've gone through already.
Yes, he
Scuffle,
has stated that
scuffle.
yes, informant came and assaulted, I have read the informant, the terrace water of the house of the accused person fell in the house, and for that reason, the informant started to fight, which led to a scuffle between both the houses. And there are 2 more witnesses who were examined. No one has stated anything about any serious injuries, Lordship. The 3rd witness has stated she has not seen the fight. The 4th witness said that again a scuffle broke out because of some arguments that took place between them. So here I am, Lordship.
So, Lord, very naturally, we should see the medical report.
Yes, medical report is totally contrary. It says laceration and it is there. I have annexed that also, Lordship. We come to page.
Previous.
They say previous, but Lordship, the injuries narrated in the medical report are totally contrary to the injuries in the charge, sorry, FIR, Lordship. In the FIR, he has stated that his teeth was broken and his
Laceration.
spinal waist bone was,
Mhm.
here it is laceration beneath the eyes and a round shaped mark on the back, Lordship. And if your Lordship goes through section 320 of
Bite mark.
yes, 320, laceration, bite mark, or that those things are not, those things don't come under grievous hurt, Lordship. So it is totally contrary, Lordship. He says teeth was broken, and one of the witnesses say,
So police examine only 4 witnesses.
yes, four
Only
witnesses.
4 witnesses.
Yes, 4 witnesses. So that is why I was praying that Lordship, for a stay, Lordship. And in the meantime, if the other side comes along, then Lordship, if there is, if I don't make out a case, then your Lordship can obviously vacate that stay.
Your
Lordship.
Mr.
MP Chaudhary,
One
Lordship.
Land
Yes.
Council and additional, oh, sorry, anything?
Otherwise, matter is today listed for orders.
Orders. But let the service be completed, heard additional PPP protocol. But the scan record has been received. However, service upon the respond number 2 informant is pending. Drawing attention to the order dated 26/6/2025, the Land Council submits that the prayer for interim stay was to be considered by this court after receipt of records. To facilitate this limited adjudication, the Learned Council has taken the court through the FIR and the statements of the 4 witnesses recorded by police during investigation. I have also perused the medical report. Indicating laceration and one purported bite mark. Full stop. In the given facts and circumstances, the further proceedings of so and so is order shall remain state till the next date of listing. That's okay.
A reminder may be sent for the up-to-date case diary. It was also called.
This will not do.
Because the
investigation
it's complete, Lordship,
Yes,
but
complete.
the 161 statements were not sent along with the TCR, Lordship, trial court record. That is why the up-to-date case diary was also called.
Some statements are here, though the handwriting is bad. You have translated.
I have annexed the statements. There's 4 points.
See, you can have a look whether it will become update. PRC 22550 of 23 within bracket corresponding ZR 868022 Learned JMFC number 4 Kamrup M.
Yes, sir.
Guwahati
Yes.
remain state board to bold coding. So this is the matter.
161 to দাদা নাছিলে মই লাষ্ট টাইম চাওঁতে আজি চোৱা নাই আগৰ পৰা চাওঁতে নাছিলে আগৰ পৰা আহিছিল মই 161 গাঁঠি দিছো আৰু স্কেচ মেপখনো মই তাতে নাছিলে
Entire CD part is not here. Entire CD is not here.
Not here.
Not.
It is submitted by prosecution that perhaps the entire case diary is not available. Therefore, issue requisition for the complete set of the case diary in scan format, in scan form. Okay.
Yes.
Now you work out the date.
Lordship have granted a stay till the next day.
First week of January.
My friend is said first week of January.
6 or 7?
Yes, any date.
6/1,
Yes, yes.
26.
Highly obliged.
No problem.
Who's the name?
Same. Same. 37.
Lordship, we are supposed to file a reply. The IA they have filed. Lordship, we
You are
are
for the
petitioner.
petitioner.
Lordship, our reply is ready, but the petitioner is out of station, so his signature couldn't be taken.
Lordship, I am for the information.
Okay,
We filed one application, 952.
for vacating interim
For
order.
vacating.
Okay,
Our reply is ready, Lordship, but the petitioner is out of station, so we couldn't attain the sign from him.
I see.
Kindly give us some time.
Is the, where is the interim order? Anyway, let's,
There is
that
some
may
eight
not
file-
detain us now, you know. They can file, you have no objection,
Yes.
then file the reply.
Lordship, can you fix a date? Because earlier two occasions.
I'll fix a date, no problem.
Lordship, on, if it's,
Because trial is going on, except the present petitioner.
I see. The interlocutory application was filed by the informant seeking vacation of the interim order dated
8/5/25.
8/5/2025, passed in criminal petition 541 of 25. Full stop. The petitioner side submits that seeks to file a reply to the stay vacating application. Prayers allowed. Stop. You may file it. You may file it in the meantime. This is the matter. We can help me with a date. It's. Is it okay for you?
Yes.
15/12.
Lordship, the interim order may comprise the interim in the main case, that may continue.
Main case has also come.
Yes, Lordship.
We have to pass an order in the main case also then. The petitioner side has taken time in the IA to file a reply to the stay vacating application, giving rise to the IA. Full stop. The interim order passed in this main petition, filed order dated 8/5/25, stands extended till the next date of listing. List on, what did I give? 15? 15/12.
Deeply obliged.
Okay.
38, 39.
Criminal appeal letter. Which matter? 38.
38, yes.
38, 39.
Connected matters. There's a habeas corp.
Lordship,
Not
we have
habeas-
filed one IA, Lordship.
I.
Yes, in item number 38,
Hmm.
to substitution of the interim resolution professional in place of the suspended management as lawful representative, Lordship. In this matter, Lordship, earlier it was represented by the suspended management, Lordship.
Okay, can I just have a look at the synopsis since you have prepared it nicely. Read petition, but it will come out as. The read petition criminal is regarding quashing of.
Yes, Lord.
With regard to the IBC's
Yes, Lordship.
aspect is there. Insolvency and bankruptcy code
IBC aspect has come subsequent.
subsequent.
Initially, there was a NIA case filed in the Gujarat.
Hmm.
Against that, this repetition criminal was filed.
Yes.
Now the process of negotiation was going on.
Yes.
So matter may be listed after some time so that if there is outcome of the, to know the outcome of the process of negotiation, because we are not having the recent instruction negotiation.
So in this IA, she's seeking a substitution
Yes.
of the, what is this called, term? IBC.
Yes, Lordship.
Ah.
The order is
But
in.
that may cause prejudice to us, so we have objection to that and we'll file an objection to that also.
Interim resolution professional.
Yes,
it's called,
The
huh?
order is in page number 15, Lordship.
Okay.
And that was it.
Page 15
15, yes, Lordship.
of the IA.
Yes, 9.1 point. May I read, Lordship?
The operational creditor has now suggested the name insolvency professional to perform the duties of the IRP. Therefore, this bench from the panel of insolvency resolution professionals hereby appoints Mr. Vishal Agarwal, an insolvency professional registered with the Insolvency and Bankruptcy Board of India, having registration so and so, having registered office so and so, as the IRP to carry out the functions as prescribed under the code, lordship. We are for the IRP, lordship. We have filed the IA.
Lordship, in this, against this order,
Mhm.
there is an appeal pending before the National Company Appellate Tribunal.
Tribunal. It's located at Kolkata,
No, in Delhi, they have filed the.
Delhi, appellate tribunal.
Yes. Because this order was obtained without serving notice upon the creditor.
So in terms of this order, they have filed this IA to appoint this, what is this?
So
called?
we'll file an objection to this because this will cause prejudice to the management. Not management, to the director, one of the director, because this case was filed by one of the directors, Sharmistha Barua, in her personal capacity also.
Yes.
And the process of negotiation is going on.
Okay.
And he is for the company, she is for the company also.
So let them file. Your good name, please. Yes, Yashmin, learned counsel, appearing for the applicant who is seeking to substitute one Sri Vishal Agarwal as
Interim resolution professional.
as interim resolution
Professional.
professional in terms of the order dated order dated
Order dated 20 August 2025, lordship.
20 August 2025 passed by the NCLT Guwahati bench. NCLT Guwahati bench. Learned counsel appearing for you're appearing for, there's only one
I am appealing for the petitioner, the original petitioner.
original petitioner, but
Sharmistha
in this IA you are appearing for the respondent number 3.
Yes.
Lordship, I'm for respondent number.
Number
three.
three, she is.
Okay.
I am for the.
No.
The other two are states. State of Gujarat, state of Assam.
Auto limited. I'm.
Yeah, Auto you are.
I am for the original petitioner and I have not been made
Yes.
party in
Yes, Lord.
this. I ought to have been made a party.
Yes, perhaps.
So they may do it.
Learned counsel appearing for the petitioner in the main proceeding, that is WP 3 oblique,
Yes.
this one
2020.
3 oblique 2024 submits that you'd like to file a reply in this IA as the prayer for appointment of the IRP would be prejudicial to the petitioner. Stop. The prayer is allowed and the reply may be filed, but you are not a party here, so she should, she has to file another IA in IA to impede you.
Simply make the correction into hand. Oh, that
It
is
has
not
gone into
permitted now.
CIS. Gone into CIS.
You will have to file an.
Yes, Lord.
Yes. The applicant may take steps to impede the petitioner as a party respondent in this interlocutory application as well. It's the learned counsel, madam,
You're for it.
on behalf of respondent number 2.
3.
Respondent number 3. 3. Auto Limited. This is the matter. When should we fix it? After
2 weeks, lordship.
2 weeks. Should we fix a date or leave it open?
After 2 weeks.
List
Because
after 2.
You will have to make.
Yes. If it doesn't get listed, you make a mention. Okay. And then there are 3 matters, 3 sets of matters. Each
Others are interconnected because.
interconnected.
But in others.
Same order or
Same
similar?
order, same order.
3 of 24. Let me see.
ওখানে 38 ফুটে আছে।
It is only in the 38, but in the other matter,
Hmm.
that was in personal capacity. That is, WPC criminal 18/2023.
3/24.
Here, this is 3/24. There is another one that is 18/2023. That is item number 39.
I'll come one by one. Mhm. Case record has been received.
Probably PCR has not come. I have not checked the file.
Not coming. The case record, the TCR has not yet been received. It was not received in August only, it was not received. It's coming from the
That.
Gujarat. That's
Yes.
it. Issue fresh reminder for the TCR. The original or the scanned?
Scan copy, because otherwise original.
Scanned copy of the TCR
process will stop.
from the court of the, that we have to mention or what? Because we cannot afford to go wrong.
Additional Chief Judicial Magistrate Rajkot, Gujarat.
Additional CJM Rajkot, Gujarat. Is it CC number 3785 of 2021?
Yes.
Huh? CC number, because if we make mistake, then again it will be CC number 3785 of 2021. So let it come.
3385.
Hmm?
3385/2021. It is reflected in.
No, sorry, this is different one then. No, নিলিখে পড়ছিল, ভুল হয়ে যাবে। But we have to mention the case record, case number. CC, in your petition, it's mentioned as 3785 of 2021. 3785 of.
The order is there. In the order, it is mentioned. That order dated, it's a long order dated 22/3/2024.
Right. Yes, true.
Here in para 3, it is mentioned.
3385,
Yes.
additional Rajkot. This is the matter after 2 weeks. On a date to be fixed by the registrar. This one is done. Now, next one is P9. 39 is also connected.
39 is also similar, relating to the. That may be tagged with this one, Lordship. This may be listed together.
Together, but what order we should pass here?
So this should be simply listed with that one.
Is it? Some additional affidavit time was taken.
Lordship, this matter actually became almost infractious, the second one.
So I don't know the subject matter because I'm handling it today only. Anyway, I'll write
The
like that.
director has expired.
Oh, okay. So list this matter along with WP criminal number 3/2024. 3/2024. This is all. No?
Highly obliged, Lordship.
That's it.
IBC is a very, very important field, actually.
Very
Insolvency.
complex also. Filing procedure is very cumbersome there.
It should not be.
Very complex.
Why is it so? Go to Baki Hoikal. Any hearing? Because I know time actually. Then let me see. You for which matter?
Item 4 below.
It's a criminal appeal.
Criminal appeal.
I like criminal appeals, but there's no time.
One problem is that the informant was made a party, but his name has been shown, but on other days he was appearing, but today most probably he was,
And he's in custody, it seems.
his career, almost 5 years, half of the sentence.
I'm just having a look. It's much time.
In this case, father is the informant.
Hmm?
The father is the informant, father, mother, and the victim. 3 of them were examined. Apart from the 3, there are 3 other villagers, and a doctor and the IO. The FIR was lost after 10 days. And the plea taken in the FIR is that there was a village meeting, and they were expecting to get some solution in the meeting.
Just a minute. Just a minute. Let us just have a cursory look, so that whether it will be possible to proceed. Otherwise, no paper book. Is there any paper book?
No, not it. No.
Arunachal, I found excellent paper books.
Excellent paper.
Excellent paper books they make. We also have. Here also we have. Here also, of course, too much load is there. They may not. But I was
Number
very
of
impressed.
cases are much more high.
Very. No. But here also I have found good paper books, but maybe they have lesser.
CBI matters.
Excellent, they have, it was really helpful. The paper books, paper books are very helpful for all kinds of appeal. Very helpful. Anyway, it will delay it further if I direct payment to. How many witnesses were there?
8.
10 witnesses.
8.
8. Sure.
8 witnesses.
Talk show. And the conviction was
10 years.
10 years.
Almost 5 years I'm in jail.
$10 years, 5 of only 4, only one section. Only one section. What do you propose? Would you like to proceed or something?
Because otherwise,
It's
also
time is
informant, counsel for the informant has to be present. Can it be fixed on day after tomorrow?
Day after tomorrow.
Can it be
It can be fixed.
kept as a part heard?
No, part heard too. Actually, we have not, strictly speaking, begun. So it may not be very correct to keep it as part heard, but we can fix it on Thursday.
Yes.
But you can. What do you say, Whatever? They have entered appearance.
Lordship.
Entered
Otherwise,
appearance.
on
Their
the
name-
other days they were present.
Their names shown in the court list.
Probably they were expecting in the matter not to be taken.
Yeah. Tag and almost. Should take hearing when we are fresh.
Yeah, Lordship.
Anyway, we can change that sometimes. Take us about our counsel for the applicant, sorry, for the appellant. And people have to learn it, additional people. It was part heard earlier, no?
Part heard, thereafter it was released because
Released.
almost more than 2 years it was kept
It
part
cannot
heard.
be. It has to be released. So though the informant side has entered appearance through learned counsel KM Hassan, but today learned counsel is not present. Moreover, there's also a paucity of time. Release the matter. You want it on Thursday? List on 27. Take a chance.
Regarding my lord, that delay, my notice in delay condemnation petition, yes, your lordship has rightly pointed out, my lord. That is, of course, in view of these victims' right to participation in every stage of trial. So delay condemnation is a.
Deepak Nayak, that's in the Supreme Court decision I was referred to.
Otherwise, there is no such Supreme Court decision which, my lord, exactly, my lord, specified that this is mandatory. But
Yeah.
in view of the, my lord, that participatory right of the
No, no,
victim,
that's
my lord,
true.
as delay condonation is
True.
also, my
I
lord,
was not sure
part of
actually.
the appeal, my lord.
True,
Yes, ma'am.
that's true.
May I leave?
Two matters. Anything else? You can make a
42.
mention on 42. What is the matter? This one?
Well, 8 years conviction.
Hmm.
8 years conviction, means 304B, he is in jail since 1.5 years. I think one of the case is acquittal, my lord, as per my opinion, my lord. But time is short.
Yes.
Yes, only
But
one.
the appeal has come up for hearing.
Yes,
Main appeal is.
appeal as well as the
This
I
thing.
also
Oh,
together.
yeah. There'll be no time for the appeal,
Yes, ma'am.
you know, also.
And if possible, I may be taken up. But only on the basis of PW2, the father deceased. Only one issue is there, no demand is here. Only father said that
Mhm.
the husband demanded some furniture.
If he wants to take up the IA, then matter may comments for order, sir.
Yes, it will be. Today,
Otherwise, the entire matter will.
yes,
take- It will be.
the
better.
matter can also be taken.
Same thing. up to
Best is, how many, I'm just trying to see how many witnesses exactly.
8 witnesses.
Eight
present.
witnesses.
All are hearsay, only parents of the
Eight witnesses.
deceased is the direct witness.
Paucity of time, paucity of time, list the
Date.
matter on, you can take a date.
First week of December, minute. Any day may be fixed.
First week of December,
11 may be fixed.
11 is,
11.
fix it on there. Take it up on,
I am obliged.
last matter.
43.
Sure, sir, waiting all day.
Lordship, no problem. But this is the NIF, they have filed a crossing petition. So whether if you lordship like to hear or may fix a date, lordship.
You take a test and for signing.
This matter is coming up in the last 5 weeks, every week. Self-imposed stay has been granted by our learned trial court. So
No,
if possible on
we can-
3, if my brother agrees, and can it be a 2 lordship? If possible, lordship, subject to convenience. Lordship. So for my part is I will only rely on 2 judgments and 2 minutes.
Paucity of time. No, you've seen the system. We can always, modify the system and make some system where the hearings come up and those who matters which do not reach, they automatically they come up
Yes.
in a subsequent list in an upgraded manner. Automatic. You can use technology also nowadays.
Yes.
Very easy. So
Because
anyway,
NIA
today it's
matter,
paucity of time.
This is a NIA
Paucity of time. Release the matter. So you can suggest a date.
Third.
Don't take it next week. 2 days I will not be available. It can be before different bench, no problem. Yes. Huh? 9,
9/12, lordship.
9. Will on that day, depending on after seeing the list, we can, if necessary, upgrade it
Oblige,
or
lord.
take it up at 2.
Oblige.
25.
None appears. So it will record all. Notice to invite how. Botagut. This none appears, but the service is not complete. So you can take instruction. The prosecution none appears. Prosecution record is come. Case diary. It's case diary has not yet come. Case diary is not yet received. Issue reminder. The prosecutions also the prosecution shall also take instructions regarding service upon respond number 2/informant. List after a week.